will simplify what occurred in court today. The court, on hearing arguments, held as follows: that the review jurisdiction of the court had not been properly invoked, and as such, the application for review was dismissed. The review jurisdiction of the court is not to be granted sparingly, especially when the decision of the court is a unanimous one, that is 7-0. The scales will most unlikely tilt in your favor when you go for a review, especially when the ruling is grounded firmly in the law. The mere repetition of arguments does not metamorphose your arguments into a correct one. So that is what we must take note of as friends of the media. Secondly, the stay of proceedings was struck out as moot. This is based on the assertion that the stay of proceedings, which is an application to put a halt to proceedings, was pending the review, but then the review had been already determined, and as such there was no need for the stay of proceedings to be heard, and as such the court gladly struck out this application. With regards to what will happen on Monday, the court held that based on another application by the petitioner, the court will then hear these applications and proceed to give a firm date for judgment. However, it is instructive to note that an order of court cannot be halted by an application for stay of proceedings, nor an application for review. So this repeated non-compliance with the orders of the court is something that is unacceptable behavior, even for any member of the bench or any court. This is unacceptable, much more the apex court of the land, and this should not be countenanced. When we proceed to the matters let's proceed to what my colleagues on the other side have stated when they came to address the media. Sometimes there are usually some misconceptions that need to be clarified. With this argument of estoppel that keeps on being bandied about, the court firmly dismissed this argument and stated that it does not apply in these circumstances. The court further held that the strength of your case does not depend on the weakness of your opponent's case, and as such, the petitioner keeps on coming to us stating that Nana Addo Dankwa Akufo-Addo did not obtain more than 50% of total valid votes cast. Where are your figures? Show us your figures. We are not getting anything from the petitioner nor his witnesses, and as such, we are still lost as to why we are in court. We also feel that the petitioner who brought us to court should actually be in a hurry to file his closing addresses, but there has been a consistent delay in this process, and we do not understand why. We have filed ours, and even when the petitioner's lawyer was on his feet today, he mentioned the fact that the Order 36 lays down the procedure for order of speeches. So in actual fact, they were to file their closing addresses, then we file our closing addresses. But the court has the power, per Order 36, Rule 1, to decide and order how this order of speeches should take place. And as such, the court, rightly so, ordered that both parties file their written addresses simultaneously, and that is firmly grounded in law. I do not hold brief for the Supreme Court, but it is instructive to note that the sanctity of the court is something that must be upheld and religiously guarded by us as lawyers, by litigants, and indeed the entire citizenry of Ghana. And especially when you are before the apex court of the land. This is our final resort when an aggrieved party brings a matter to court, and as such, this sanctity must be jealously guarded. Justice is not a concept that is born out of nothing. It is firmly grounded and must be prescribed within the law within statutes and decided cases. So when there is the bandying around of the need to do justice, it should be within the ambit of the law. And that is very important for us to note. Litigation cannot go on in perpetuity. This matter must come to an end one way or the other. Just because of the repetition of arguments and the consistent review, the consistent application for review, does not mean that this matter will not come to an end. It has to come to an end. And the orders of the court were specific. For the filing of closing addresses, we are happy that the court expressly stated that on Monday, it will give a date for judgment. So as we, as Ghanaians, prepare to come to the end of this momentous election petition, we would call on all parties to gladly accept any judgment, the judgment that comes out of this matter, be it in their favor or not. And I would like to remind all of us, in 2013, His Excellency Nana Addo Dankwa Akufo-Addo instituted an election petition in the Supreme Court. When the judgment was given, he did not agree with the judgment, but he graciously accepted the judgment of the court, and he stated categorically that he does not agree with same. We are hoping that whatever the verdict, whatever the judgment that comes out of this matter, that any party that is aggrieved will gladly and graciously, as our client did, in whom we are so proud that he did same, that this will take place when the judgment is delivered finally. I would like to end on a lighter note to state that this petition reminds me of my favorite author, Chinua Achebe, in his book, Things Fall Apart. And what he says is that indeed, the petition cannot hold. Thank you. We'll now invite some questions.
No question.
Okay. That's good. Okay. All right. So now Fati will take the tree translation.
Well done.